Hello, this is Roger Royce. I'm a lawyer in Silicon Valley, California, and this week the Supreme Court, this is the week of October 12th, and the Supreme Court has this week decided not to hear a case attempting to expand Section 230 of the Communications Decency Act of 1996. Now, you may recall that Section 230 is the rule that shields platforms from any liability for content posted on their site. And this particular case came out of California. It was an appeal. It was a case brought against the online platform Tinder for damages that were suffered by a young user of the platform from a contact he made on that platform. Was dismissed in the district court. That dismissal was upheld by the Court of Appeals for the Ninth Circuit, and it was appealed to the Supreme Court. Now, you may recall Section 230. Everybody in Silicon Valley and everywhere knows that this law, enacted in 1996, was enacted to just pave the way for online innovation for internet platforms. And a lot's changed in 30 years, clearly, as to what an internet platform is and what it can do. And therefore, there's been a lot of people been calling for an expansion of 230 or maybe some additional exceptions when the platform itself really has a lot more to do with the content than it ever used to have. For example, it can promote content to people, it can highlight it, it can recommend content, for example. And in fact, some of those on the Supreme Court that wanted to examine the bounds of 230 were Justices Gorsuch and Thomas. So it's sort of gaining some steam, but not this week. Now, just backing up a little bit, in the law, 230 is traditionally distinguished between publishers and speakers. So, for example, a newspaper, a magazine, a broadcast statement, publisher or speaker, they're just reporting the news, as opposed to a distributor, like a newsstand, a library, or a retailer. So we're trying to take this old wine and put it into new bottles, in effect. And the idea was because publishers had editorial control, they had strict liability for any illegal content. For example, if our local newspaper published something that was defamatory, I could sue them for that, right? Because they had the decision, they made an editorial decision to publish it. On the other hand, as somebody, the paper boy who delivered my paper with that defamatory comment, he would not, because he has no editorial control. And you're not expecting the paper boy to read every article in the newspaper before they toss it onto so does anyone even get papers anymore? But anyway, you get the idea. Well, you remember back in the 90s, there was a lot of question about this. So CompuServe was sued, first of all, and a federal court held that they were a distributor, not a publisher. Okay, that's good. But then another court in New York went completely the opposite way and said there was an ISP called Prodigy that was determined to be a publisher rather than a distributor because it every once in a while moderated its online comments. So you can see the perverse incentives there. If you moderate it, you have liability. If you just keep your eyes closed, you don't have any liability. So Congress stepped in 96 and enacted Section 230. So that no provider or user of an interactive computer service shall be treated as a publisher or speaker of any information provided by another information content provider. I'm quoting from a case. Okay, so what's happened since then? Well, since then, we've gotten the application of Section 230 in places where it's a little fuzzier as to whether there really is that editorial content. And so there's been a push to either narrow or broaden the scope of 230, depending how you look at it. So if we were to narrow the scope, we could leave more online service providers vulnerable to lawsuits because they can't claim immunity, and that might make them a little more responsible about what they do online. For example, maybe a particular social media site wouldn't be advocating to teenage girls any sites that show you how to hang yourself, for example. Opponents of this reform now say that if we do this, we're going to really hinder free speech, because we're going to find that these platforms are going to be super careful about what they want to, what they're willing to publish. And in fact, we've already seen that in some other areas. So so an expansive interpretation says we need that for a free and open internet. I'm not going to weigh in on who's right. I'm just going to tell you that this is an area of the law that is developing, but not so much as of today, because the Supreme Court has left things alone and did not hear the case. So stay tuned for every week, where we bring you original legal content on issues of interest to the technology community. I'm Roger Royce, a startup lawyer in Silicon Valley, California.